hear argument this morning in consolidated cases number 13354, Sebelius, Secretary of Health and Human Services versus Hobby Lobby Stores, and 13356, Conestoga Wood Specialties Corporation versus Sebelius. Mr. Clement.
Mr. Chief Justice, and may it please the Court, when a federal government agency compelled employers to provide something as religiously sensitive as contraception, it knew that free exercise and RFRA claims would soon follow. In particular, the agency itself provided exemptions and accommodations for the religious exercise of a subset.
Is your claim limited to sensitive materials like contraceptives, or does it include items like blood transfusion, vaccines, for some religions, products made of pork? Is any claim under your theory that has a religious basis, could an employer preclude the use of those items as well?
Well, Justice Sotomayor, the first step in the analysis would be to ask whether or not there's a substantial burden on religious exercise. I do think this case is, in a sense, easier than most of the examples that you've brought up, because here's one where it's so religiously sensitive, so fraught with religious controversy, that the agency itself provides a certain number of exemptions and accommodations. So that's one way I think that you'd address the first step of the question.
Well, just take one of the things that Justice Sotomayor asked about, which is vaccinations, because there are many people who have religious objections to vaccinations. So suppose an employer does and refuses to fund or wants not to fund vaccinations for her employees. What happens then?
Well, if we assume we get past the substantial burden step of the analysis, then the next step of the analysis is the compelling interest and least restrictive alternatives analysis. And every case would have to be analyzed on its own. I do think in the context of vaccinations, the government may have a stronger compelling interest than it does in this context, because there are notions of herd immunity and the like that give the government a particularly compelling interest in trying to maximize
blood
the number
transfusions?
The blood transfusions, again, each one of these cases I think would have to be evaluated on its own and apply the compelling interest, least restrictive alternative test and the substantial burden.
So really every medical treatment, and Justice Sotomayor is quite right, that there are quite a number of medical treatments that different religious groups object to. So one religious group could opt out of this and another religious group could opt out of that, and everything would be piecemeal and nothing would be uniform.
Well, Justice Kagan, nothing could be clearer than when Congress passed RFRA, Congress made a judgment that RFRA was going to apply to all manner of federal statutes. And I think what Congress...
Mr. Clement, maybe it seemed clear then, but since RFRA, just as before RFRA, Congress has continued to write into federal legislation specific religious exemptions for some, but not everybody, for individuals, sometimes religious institutions. So if it was all that clear that RFRA took care of it all, why did Congress continue after RFRA to pass these laws focusing the exemption on an individual religious institution? Well, those, as I take your argument, all of those laws, and there are more than half a dozen, were unnecessary. Once RFRA was on the books, Congress didn't have to do that anymore.
You were beginning by giving us a framework for your argument. Do I think of this as a statutory case? Of course, the First Amendment is on the stage at some point here. But I take it you can prevail just on the question of statutory interpretation. And if that is so, are there any statutory rules that work in your favor, that is to say, avoiding a constitutional question? How do we think about this case? Primarily as a statutory case?
Obviously, one of my clients has before you right now a free exercise claim, and my other client has a free exercise claim that's live in the lower courts. So those issues are preserved.
There's another respect in which this, even as originally enacted, does not track the pre-employment division versus Smith law. That is to say, the compelling state interest test in the prior cases was never accompanied by a least restrictive alternative requirement. That was an invention of this law.
I think that goes right.
Your argument it would make no difference if it were there are 20 FDA-approved contraceptives, all of them covered by the Health Care Act.
I think
you picked out, in one case, 3, and in the other case, 4. Suppose the employer says contraceptives altogether are against my religion, so I'm not going to give any contraceptive coverage.
Well, obviously, Justice Ginsburg, I didn't pick these out. I mean, my clients and their religious beliefs identified these as problematic.
But your argument, it seems to me, would apply just as well if the employer said no contraceptives.
I think that's a fair point, Justice Ginsburg, and the government's own accommodations where they offer them to religious groups and religious employers like nonprofit hospitals also applies to whatever the religious beliefs of that provider are. So if they extend to all 20, then the exemptions apply to all 20. If they only extend to 4, then the exemption applies to all 4.
Are there ways of accommodating the interests of the women who may want these particular drugs or devices without imposing a substantial burden on the employer who has a religious objection to it?
There are ample less restrictive alternatives, Your Honor, and I think they all flow from this fact that this is ultimately about who's going to pay for the subsidy.
Those are alternatives that you're asking the government to incur or the person to incur.
Well,
I mean, there isn't an alternative that doesn't put a cost on someone else.
Well, it's funny about this particular mandate because the government's position is this is actually a cost-free mandate, that whatever you pay out in contraceptions, you're going to make up and not having to pay for other coverages. And so one alternative, one less restrictive alternative, is what's done in the accommodation for nonprofit employers like hospitals, where basically they tell the insurance carrier or the plan administrator that you pick up the cost for this, and then essentially it'll be cost-neutral from you. I could have just 1 second more to say that the agency point that Justice Kennedy has pointed to is tremendously important because Congress spoke. It spoke in RFRA. Here the agency has decided that it's going to accommodate a subset of the persons protected by RFRA. In a choice between what Congress has provided and what the agency has done, the answer is clear. Thank you, Your Honor.
Thank you, counsel. Counsel, the case is submitted.